considered for that and take part of that program.
All right, the court is going to sentence you to 8 years deferred adjudication. Take in consideration 2023 CR 7315, 2024 CR 5389. All right, court is calling 2024 CR 5390, State of Texas versus George Laverne Hawkins. Could our parties announce for the state?
Andrew Harris, setting with the state.
Defense?
Renee Munoz.
And are you Mr. Hawkins?
Yes, ma'am.
You entered a plea on June 20th, 2024 to the offense of assault of a peace officer. According to the plea bargaining agreement, punishments be assessed at 6 years in the prison. The state is silent on your application. They're taking in consideration 2023 CR 7315, 2024 CR 5389, County Court Cause number 729000. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, Judge.
Any objections to the PSI report? State?
No, Your Honor.
Defense?
No.
Have both parties had a chance to review the TAP evaluation? State?
Yes, Your Honor.
Any objections?
No, Your Honor.
Defense?
Yes, Judge, and no objections.
All right, the state is silent. Defense, do you have any witnesses?
No witnesses at this time, Judge, only a clarification, explanation / argument.
All right, you may proceed.
Thank you, Your Honor. With regard to Mr. Hawkins, I've been dealing with him for some time, assisting with these legal matters. He has been keen and set on taking advantage of the specialty court because I believe that specialty courts are designed for individuals like Mr. Hawkins that are dealing with issues and they need that support and structure from a team that can help them understand their issues and put different resources in the community. We did apply for Veteran Treatment Court on May 30th. He was denied that court, albeit being a veteran and having served this country honorably, receiving honorable discharge, because there is not a sufficient nexus between his issues and the service, according to the program, Judge. So after that denial of that program, we went ahead and had him considered for lifetime recovery. We did reach out and have him screened, and we do have documentation here that he does meet criteria and can go there if allowed by the court. We also reached out to felony drug court in advance to see if he would meet criteria for that program as well. I do have documentation here that he does meet criteria. However, he was denied at that time because it is obviously, the court is well aware, post-adjudication program, and we're not at that stage as of this time. So, Judge, he's been dealing with some issues. He did graduate from University of Houston with an accounting degree in 2010. However, some of the issues he's dealing with, namely surrounding substance use, he uses methamphetamine, things of that nature, had led him to be homeless and have some interaction with law enforcement. The nature surrounding these offenses are not of an egregious type. He was arrested and fled out and made contact with the officer's shin, I believe. The other offense that he was charged with, Judge, he was actually at Cross Point, excuse me, and he was going to be emergency detained from there and taken to a facility. However, he was routed to the jail upon them alleging to have spit on the back of the officer's head. So there is some issues here. We don't believe that the issues are necessarily attributable to a criminal mindset, more so a cry for help and need for treatment, Judge. So we're asking the court to consider the avenue of treatments with inpatient treatment facility. I referenced the PSI, and the PSI is recommending inpatient treatment. We're asking for that to be ordered, Judge, so he could be transferred from here to lifetime recovery, have him doing well.
But what is this says in the report, he declined to have a mental health screening, stating he didn't want to sign for any of the department's dual diagnosis programs or residential programs because he doesn't like the idea of sitting in jail for 4 months just to go to treatment.
Yes, Judge, and if I might clarify that, I believe he's maybe had heard word around the jail that maybe the DDRF times are long. They can result in months-long waits to get him into facility. And I think that he's been in custody for a number of months now. He's wanting to get a hold on his treatment and recovery, and believes that lifetime recovery would probably be less of a wait time to get him into that treatment, Judge. So I did explain that in the PSI with him, and he stated that was his concern about the mental health facility being a much longer wait, and him waiting in custody until a bed opens up, where in contrast to that, the Bear County is notifying me that they do have space for him at Lifetime Recovery, and they can readily transfer him there to get him on the road to his recovery and to turn his life around. And my suggestion, I think the court hopefully is on the same mindset, that if he does that, it's going to put him in a better place to work the felony drug court program, which he meets criteria for, and give him that access to that specialty court, which we were vying for and trying to get with the Veterans Treatment Court, but he did not meet criteria for that, Judge. For these reasons, we're asking respectfully for the court to consider that. I do have the treatment documentations of them evaluating him, Judge, as well, for the court to consider, just to verify. It's my understanding, confirmed with the state of Texas representatives, that they're silent as to this request because they see the need for him to get some treatment and some help. And he's been patiently waiting for us to try to get it together to hopefully create these avenues for him. And I think we have some options and availability here, Judge, to get him some treatment over just incarceration.
All right. I see that he is a veteran and was honorably discharged.
Yes, Judge.
And it appears from reviewing the history and reviewing the instant case that there's an issue with drug use. There's an issue with mental health. Now, whether that mental health occurred due to his military service or not, the court doesn't have that information. So I'm going to give you a choice. Sometimes I can give people choices. Sometimes I can not give them choices. I always tell people, you can't choose how your recovery is going to look like in the sense of, I want this treatment, I don't want that treatment. Because if you could do that and write your own program, we wouldn't be here and you wouldn't have the criminal history that you have. So I can sentence you to 4 years in prison, or what's going to end up happening is I'm going to refer you back to felony drug court because I know they have a dual diagnosis program. If they don't accept you, you're going to safety. So those are your choices.
Is, Your Honor, for clarification, the felony drug court dual diagnosis, is that within the felony drug court
Yes.
program? Would it still be an avenue for him to get treatment at Lifetime Recovery? If
He's going to felony, if felony drug courts accepts him, then drug court will set his conditions. If felony drug court does not accept him, he's going to safety.
Okay, yes, understood, Judge. If we could be considered for the felony drug court, and then whatever recommendations they may have, as long as they're reasonable, Judge, we'll definitely, he'll be on board with that.
No, I mean, felony drug court,
Yeah.
it doesn't matter if people think their recommendations are reasonable or not. It's, if he goes to felony drug court, then felony drug court is going to set his conditions. If he goes to felony drug court and he says, I don't want this, then what's going to end up happening, a motion to revoke is going to be filed.
Yes, Judge, I understand. And ultimately, we're looking for an avenue for him to get treatment through a specialty court. So that's with the recommendation of felony drug court piece. He wanted me to voice that he would like to be considered for that and take part of that program.
All right, the court is going to sentence you to 8 years deferred adjudication. Take in consideration 2023 CR 7315, 2024 CR 5389, 729000. He's to remain in custody for the following evaluations. And then MIC evaluation, regular reporting by Zoom or in person, regular random UAs, proof of employment or SSI within 45 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with my. And I'm sorry, instead of the anger management probation, it's going to be this a hostility management aggression control program. There's to be no contact with K Talley, Talley, and probation with regards to the MIC. Maybe the best place for that, if he's not accepted in to felony drug court, once he's relieved from safety, if we do the mental health treatment through the VA. Probation, also, we'll do 200 hours of community service restitution. Probation, is there anything else he needs? I'm sorry?
No, sir.
Is there anything else you need from the court to be successful?
No, Your Honor. Thank you.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do
Understood.
you understand?
Yes, ma'am.
And the court did not see any restitution amount for the officer. So state if there is going to be restitution to the officer, you will need to provide that within 30 days.
Yes, Your Honor.
All right, is there anything else?
Nothing further, Judge. Thank you for allowing us to be heard on this matter.
All right, thank you. All right.
atmosphere
Court
is
is calling
tense as George
2024
Hawkins,
CR
a University of Houston
5390,
accounting
State of
graduate,
Texas
now
versus
homeless
George
and
Laverne
struggling with
Hawkins.
methamphetamine
Could I have parties
addiction,
announced for the
awaits his
state?
fate for assaulting a peace officer. His defense attorney paints a picture of a man in a cry for
Renee
help,
Munoz.
not a
And are you
criminal
Mr.
mastermind.
Hawkins?
Yes,
He
Your Honor.
details
You
efforts
entered a
to get
plea
Hawkins into specialty
June
courts,
20th,
including Veterans Treatment
2024,
Court, which denied him, and a
the
specific
offense of
inpatient
assault
facility
of
called
peace
Lifetime
officer.
Recovery. The attorney
to the plea
emphasizes
bargaining
Hawkins
agreement,
wants treatment
punishment
and
is to be
argues
assessed
this is
at
the
6 years
best,
in the
most
prison. The
available
state is
option
silent
to
on your
turn his life
application.
around. But
They're
Judge
taking in
Stephanie
consideration
Boyd sees a different
2023
pattern. She
CR
coolly notes a
7315,
damning detail from the
2024
pre-sentence
CR
investigation report
5389,
that Hawkins
County Court
declined a
cause
mental
number
health screening in jail. His reason? He didn't want to wait
Have both
months in
parties had a
custody for a
chance to review the
state dual
PSI report?
diagnosis bed.
State,
To Judge Boyd,
Yes, Your
this
Honor.
isn't a
Defense?
Yes,
logistical
Judge.
concern.
objections
It's
to
a
the PSI
fundamental
report?
failure
State?
to surrender
Your
to the
Honor.
process.
No.
In a moment
both
that
parties had a chance
destroys
to
any
review the
illusion
TAP
of the defendant
evaluation?
setting the
State?
terms, Judge
Your Honor.
Boyd's
Any
voice
objections?
rings with
No, Your Honor.
authority.
Defense?
I always tell
Yes,
people
Judge,
you
and no
can't
objections.
choose how your recovery
All
is
right,
going
the
to
state
look
is
like.
silent.
Because if you
Defense, do
could
you
do
have any
that and write your
witnesses?
own
No
program,
witnesses at
we
this
wouldn't
time,
be
Judge.
here.
Only
She then
clarification,
delivers
explanation,
a
/
crushing
All right, you may proceed.
ultimatum,
Thank you, Your
offering
Honor.
the choice
With regard
she
to Mr.
controls,
Hawkins, I've been
a
dealing with him
4-year
for
prison
some
sentence,
time, assisting with
or
these
a
legal
referral
matters.
to the court's highly
He has been
structured
keen and
felony
set
drug
on
court
taking
program,
advantage of the
which
specialty
includes
court
a dual
because I
diagnosis
believe that
track.
specialty courts are
If
designed for
drug court
individuals like
rejects
Mr.
him,
Hawkins
he goes
that
to a
are
state
dealing with
facility,
issues and they need that support and
SAFPF.
structure
There is no
from
third
a team
option.
that can help
When
them
the attorney
understand their
tries
issues
to subtly
and focus different
advocate again
resources in
for
the
the
community.
preferred lifetime
We did
recovery
apply
path,
for Veteran Treatment
Judge
Court
Boyd
on May
shuts it
30th.
down
He was
definitively.
denied that court,
The defendant's
albeit being
attempt to
a
control
veteran
his
and having
recovery
served this
has
country
just
honorably,
backfired
receiving an honorable
spectacularly.
discharge
Without
because there is
further
not a sufficient
debate,
nexus
Judge
between
Boyd sentences
his
Hawkins
issues and the
to 8
service
years
according
of
to the
deferred
program, Judge.
adjudication
So
probation.
after
Her
that
list
denial
of
of that
conditions
program,
is exhaustive
we
and
went ahead
strict.
and
The drug court
had
referral,
him
possible
considered for lifetime
SAFPF,
recovery.
regular drug
We did
testing,
reach out
anger
and have him
management,
screened, and we
specified
do
as
have
a
documentation
hostility
here that he
management
does meet
aggression control
criteria,
program,
and can
no
go there if not
contact
by
with
the court.
minors,
We
and a
also reached out to
lifetime
felony
ban
drug
on
court
working
in
as a home
advance
health
to
care
see if he would
provider.
meet criteria
In
for
one
that
final
program as well.
decisive move,
I do have
she waives
documentation
his
here
right
that
to
he does meet
appeal.
criteria.
Judge
However, he was
Boyd
denied
has
at
not
that
just
time
sentenced a
because
man,
obviously the
she
court
has
is well aware
systematically
post-adjudication
destroyed his
program, and we're
resistance
not
to
at
the
that
court's
stage
authority,
as of this
making
time.
it unequivocally
So,
clear
Judge, he's
that the
been dealing with
path
some
to
issues.
redemption
He
is
did
paved
graduate
with
from
compliance,
University of
not
Houston with an accounting degree in
negotiation.
2000.